Good morning. See, whenever any act is passed for the purpose of attracting particular section of people to woo the votes, that acts are being challenged. So, whenever you want to challenge the act, first you should go to Constitution and verify with the Schedule 7. There shall be list 1, list 2, list 3. The subject upon which that act was passed, whether comes within list 1 or list 2 or list 3, then only you can challenge it about the competency of that particular legislation being passed either by the state government or by the union government, or the procedure to follow the subject which is applicable for both state and union government. Here what actually happened, what is law of repugnancy? Law of repugnancy and occupied field, pith and substance are related to when act is being passed over the subject scheduled at list 2, concurrent list. Otherwise, the act which is being passed by the state legislature without power under list 3 or by union government without power under list 1. That is something different. That is regarding competency. The competency of passing legislation by the state or union is something different. The competency of act being passed, the subject scheduled in concurrent list, then only question of law of repugnancy applies. Here actually Assam Rural Health Regulatory Authority Act was passed by the state government of Assam. The act was enacted to provide for the establishment of a regulatory authority in the state of Assam to register diploma holders in medicine and rural health care, to regulate their practice in medicine in rural areas, and to regulate the opening of medical institutions, to impart education and training for the course of diploma in medicine and rural health care. So that was challenged. When that was challenged, the Supreme Court in AR 2023, Supreme Court 721, Barul Islam and others versus Indian Medical Association. There the Supreme Court has said the subject upon which the act was passed is list 1 entry 66. List 3 entry 25 is something different. Therefore they say, since the state legislature have no right to enact a law in respect of modern medicine or allopathic medicine contrary to the standard that have been determined by central law, Indian Medical Council Act 1956. Therefore the Act 2004 of 19 of 2004 passed by Assam Rural Health Regulatory Authority Act passed by Assam state legislature has been struck down as ultra virus to the constitution. So if you want to challenge that, you kindly go through this judgment so that you can understand how the arguments are advanced challenging the act when act is detrimental to the framers of the constitution and the basic structure of the constitution. So one thing you should understand, that here whether allowing these sort of second grade medical practitioner in rural areas to be considered or not, it is a matter of subject where if any public interest litigant or lawyer wanted to bring that provisions, that means somewhat allowing quacks or nurses, midwiferys practicing some section of medical practice. This is being allowed, midwiferys are allowed in the rural areas. Like that, for small attending patients, though the act, the intention of the Assam legislation was good because Assam state was comprised of forest as well as hilly areas. So there may be problem for poor people, tribes and downtrodden people approaching the hospitals far away situated. Though intention was good, but because of this structure of the constitution, the Supreme Court has struck down. Kindly mind it and try to bring any resolution or movement compelling the union government to suitably amend the Medical Councils Act, Indian Medical Council Act, so that these sort of second grade medical attendants are allowed to practice medicine for small medical care required by the common people at rural areas. I hope you understand. Before that, if those who are interested in challenging any act, go through this entirety of judgment, the judgment running multi-number of pages. So they are also scheduled what all are the duties of the Indian Medical Council Act and what all are the regulation of the Indian Medical Act and Assam Rural Health Regulatory Act. So the difference were those seems to be very clear, authentic, and the efforts were good, but unfortunately, so it should not be implemented for want of structural defect in Constitution of India. I hope the Union government, the legal luminaries, honorable judges, retired judges should understand and write an article on this, whether such a requirement of second grade doctors to attend the patients in rural areas with regulated norms and conditions, and the Act, Assam Rural and Health Regulatory Authority Act, also permits constitution of institutions to part with training for these second grade doctors. I hope you understand. Best wishes.